Effective sanctions compliance relies on robust, multi-layered screening policies and procedures that encompass client onboarding, transaction monitoring, third-party due diligence, and the integration of advanced technology and best practices to manage risk and regulatory obligations. Client screening is a critical component of sanctions compliance, requiring organizations to screen clients during onboarding and throughout the business relationship against relevant sanctions lists, such as the OFAC SDN list, the UK sanctions list, and the EU consolidated list. This process extends to beneficial owners and related parties to identify indirect or aggregated ownership by sanctioned individuals, in line with the 50% rule. A risk-based approach is essential, with high-risk clients requiring frequent rescreening, while lower-risk clients are reviewed periodically or upon significant changes such as new sanctions designations. Automated systems with fuzzy logic and phonetic matching are recommended to handle large data volumes efficiently and reduce false positives. Confirmed matches must be promptly investigated with immediate blocking or rejection of transactions and timely regulatory reporting to ensure compliance and audit readiness. Transaction screening is essential for identifying and preventing prohibited payments and trade activities. Financial institutions must implement real-time screening of payment messages such as SWIFT and ISO 20022 formats to ensure transactions are checked against updated sanctions lists before processing. This includes screening all parties involved, as well as goods and shipping details in trade finance, with a focus on dual-use goods that may have civilian and military applications. Advanced technologies such as AI-driven fuzzy logic and machine learning are increasingly used to detect name variations, transliterations, and deliberate obfuscation, reducing false positives and operational delays. Regulatory bodies like OFAC, FATF, and the EU require enhanced due diligence for high-risk jurisdictions or goods. Effective alert management is critical. Alerts must be promptly investigated, escalated if necessary, and confirmed matches must result in immediate transaction blocking and regulatory reporting. Comprehensive audit trails and regular system updates are vital to ensure compliance and support regulatory inquiries. See third-party screening. Third-party screening extends sanctions compliance to intermediaries, suppliers, and agents, addressing growing regulatory focus on supply chain and counterparty risks. Organizations must adopt risk-based due diligence frameworks, screening third parties at onboarding and regularly thereafter, with enhanced due diligence (ED) for high-risk partners, such as those in sensitive jurisdictions or with complex ownership structures. EDI includes verifying beneficial ownership, conducting background checks, and ongoing monitoring for risk changes. Contracts should include sanctions compliance clauses, requiring adherence to laws and allowing termination for breaches. But ultimate compliance responsibility remains with the organization. Failure to implement robust screening can lead to severe penalties and reputational damage. Key challenges and best practices. Sanctions screening faces challenges like poor data quality, false positives, and technology integration. High-quality, standardized data and AI-driven tools are essential to reduce false positives and detect name variations or obfuscation. Automated systems with real-time list updates and robust algorithms help manage frequent regulatory changes and large transaction volumes. Integrating sanctions screening with broader All-My-Keek programs ensures holistic risk management. Comprehensive audit trails, regular system testing, and independent validation are critical to meet regulatory expectations and maintain compliance. To sum up, a modern sanctions compliance program is a dynamic, risk-based system that integrates regulatory expectations, advanced technology, and industry best practices. By focusing on the 5 foundational elements, employing robust risk assessment methodologies, and implementing comprehensive screening policies, organizations can effectively manage sanctions risks and demonstrate compliance to regulators. Continuous improvement, automation, and thorough documentation are essential to meet the evolving challenges of global sanctions enforcement.